Karibu tena mtazamaji. Kabla ya kurejea kwenye mazungumzo, tunaenda moja kwa moja hadi mahakamani ambapo Mahakama Kuu inatarajiwa kutoa uamuzi wa kati ya Kenya Kwanza na Azimio ni nani aliye na wengi bungeni. Tufuatilie matukio mbashara kutoka mahakamani.
Within the text of the charter, the interpretation should be a generous rather than a legalistic one aimed at fulfilling the purpose of the guarantee and securing for the individual the full benefit of the charter's protection. At the same time, it is important not to overshoot the actual purpose of the right or the freedom in question, but to recall that the charter was not enacted in a vacuum and must therefore be placed in its proper linguistic, philosophic, and historical context. Close of quote. The Supreme Court of Kenya has considered the principle of holistic interpretation in the matter of the Kenya National Commission on Human Rights 2014 EKLR and observed thus. But what is meant by a holistic interpretation of the Constitution? It must mean interpreting the Constitution in the context. It is the contextual analysis of the constitutional provision, reading it alongside and against other provisions, so as to maintain a rational explication of what the Constitution must be taken to mean in the light of the history, of the issues in dispute, and of the prevailing circumstances. Such a scheme of interpretation does not mean an unbridled extrapolation of discrete constitutional provisions into each other, so as to arrive at a desired result. Close of quote. Within this background, we now turn back to the issues that we have singled out as germane to the determination of this petition. The constitutionality of the Speaker's ruling of 6 October 2022, as noted, is the primary issue about which this Honorable Court is concerned. It is whether the ruling violated or contravened the Constitution. To be precise, the question with which the court is confronted is whether the ruling is consistent with Article 108 of the Constitution on the majority and minority party in the National Assembly and their respective leaders. This article reads as follows. Party leaders. There shall be a leader of the majority party and a leader of the minority party. 2. The leader of the majority party shall be the person who is the leader in the National Assembly of the largest party or coalition of parties. 3. The leader of the minority party shall be the person who is the leader of the National Assembly of the second largest party or coalition of parties. 4. The following order of precedence shall be observed in the National Assembly. A. The Speaker of the National Assembly. B. The leader of majority party. C. The leader of the majority party. Our task is to interpret and apply this provision to the Constitution and in the process determine whether or not the Speaker's ruling is consistent with the same provision. In doing so, we must discount at the outset the notion that we are somehow sitting on an appeal against the Speaker's ruling, or that we are exercising supervisory jurisdiction over the National Assembly. We have to say more on this issue. We are mindful that Article 117 of the Constitution provides for among other things, the freedom of speech and debate in Parliament, and also privileges and immunities of Parliament. Article reads as follows. 1. There shall be freedom of speech and debate in Parliament. 2. Parliament may, for purposes of orderly and effective discharge of its business, of the business of Parliament, provide for the powers and privileges that and immunities of Parliament, its committees, the leaders of the majority party, the chairpersons of the committees, and members. Pursuant to Article 117 of the Constitution, Parliament enacted the Parliamentary Powers and Privileges Act, Cap 6. The preamble to the Act provides as follows. I read. An Act of Parliament to give effect to Article 117 of the Constitution to provide for the powers, privileges, and immunities of Parliament, its committees, its leaders, the leader of the majority party, the leader of the minority party, the chairpersons of committees and members, to make provisions regulating admittance to and conduct within the precincts of Parliament and for connected purposes, close of quote. The Act at sections 11 and 12 makes provisions for immunity of proceedings of Parliament by providing as follows. 11. Proceedings not to be questioned in courts. No proceedings or decisions of Parliament or the committee or powers of and privileges acting in accordance with this Act shall be questioned in any court. 12. Immunity from legal proceedings. No civil or criminal proceedings shall be instituted against any member or for words spoken before or written in a report to Parliament or a committee or by reason of any matter or thing brought by him or her therein by a report, petition, bill, resolution, motion, or other document written to Parliament. 2. No civil suit shall be commenced against the Speaker, the leader of minority party, the leader of minority party, chairpersons of committees, and members for any act done or ordered by them in the discharge of the functions of their office. 3. The clerk or other members of staff shall not be liable to be sued in a civil or joined in any civil proceedings for an act done or ordered by them in the discharge of their functions relating to proceedings or either house or committee of Parliament. I'll take a sip of water.
Apologies.
I like not to get to see some water. So we shall proceed.
Na mtazamaji, ni matukio pale mahakamani ambapo majaji wanatarajiwa kutoa uamuzi wakati ya upande wa Kenya Kwanza na ule wa Azimio ni nani walio wengi katika bunge la kitaifa, na hapo sasa ndipo sasa tuna